We thank you, Heavenly Father, for allowing us to meet here today in your name. We ask that you open up our minds and our hearts to this law, because all the law is your law. We ask this through your Son, Yahushua. Amen. Do we have any announcements? Okay. I have one, it's a little one, virtual audience. Hey, don't call me and say, gee, how come I'm not getting any more tapes left? You get 2 warnings. After the warnings, you go off the list. So I don't want to hear this call, oh, I never received it. Yes. Maybe I goof up and one time you don't get it, but you always get 2 notices, so.
Was it last night or the night before? 2020 ran an article of Lakewood, Ohio about the tearing down the homes and for new construction. Yeah, well, they were using eminent domain, taking your property away from you and giving it to somebody else. The city was taking their property and then they would give it to somebody else to construct the buildings. And one of the things on there, if you saw it, everybody in Lakewood had to have a 2.5 bath, 4 bedrooms, attached garage, 2-car garage, and if it didn't, they were subject to, I can't remember the name or the term they used. And the guy that reported this said, well, that includes the mayor. So I guess they're either going to, Lakewood passed that ordinance that you had to have it, and then they're going to take the houses for whatever, how they're going to take them, I don't know, but it was eminent domain. And on the program, they also stated, I think it was Mesa, Arizona, already did that. And there was another place that I don't remember where, but they talked of at least 3 places. And it's being done all over the country. If they want your property, of course, we all know that we don't own our property to start off with. So that's starts off with a loser to start with. Kiss it goodbye. But it was interesting to watch the Lakewood, Ohio got on it was either Dateline or 2020 or one of those programs. I think it was Thursday night. It was interesting. Oh, they did? Well, Channel 5, I think, picked it up at the 11 o'clock news that night also. But from the looks of it, if these people fight it and can win, there's going to be hell to pay all over the place, which it ought to be. But like I told my wife, I said, I don't know what he's arguing about. We don't own our homes. Like the guy said, I bought it. It's mine. Well, it ain't. They don't have it. They don't have clear title. It's all a fiction, illusion.
Okay, any other announcements? Victoria has gotten back from her Massachusetts seminar, and she's got Daytona Beach, Florida coming up October 3rd through 5th, San Francisco October 24th and through 26th, and particularly we want to announce the San Antonio, Texas seminar November 7th through 9th. So far they have not gotten any responses. Hello, people in Texas. Are you people all dead at the Alamo? Or now's the time to get on the computer to www.angelwiththeinkwell.org and find out about the contacts for that seminar, and let's support it, or else you may not get one. It's supposed to be at the Marriott on the Riverwalk, 4 miles from the Alamo. And so, if you people are interested in Texas and any of those other places that I mentioned, please get on the horn and get going to sign up for those seminars. Everybody that is going to those is getting good feedback. There was a good set of tapes made in Massachusetts at that one. If people are interested in the audio tapes, I know Joe Sherry last week announced that the Cleveland tapes are available. It's possible the Massachusetts tapes might also be available too. So if you're interested in those, contact the appropriate people. Last week we said we would probably talk a little bit about public notaries. It's interesting that since the court systems are all foreign tribunals, and they're basically the artifices of a democratic society, which is a military-type society, that being foreign military courts, one should have a council of the military or license to the military to go into those courts. It's interesting that probably as few years ago as maybe 6 or 7, patriots were really starting to understand that the only way to prevail on any legal issue, either civilly or criminally, would be literally to first have an administrative process or an administrative proceedings that was concluded before those issues were brought into the public domain, either at a court or whatever. And I know that one of the Right Way Law members out in Seattle, Washington, was instrumental in developing this administrative procedure as far as the patriots are concerned. And Kenny out there was really teaching people how to do it. Kenneth Wayne, what was his last name again? Forgot. Yeah, it'll come to me in a minute. Pardon? Nah, not Raymond. Kenneth Wayne. Kept hearing his name all the time. I've been out there. He's a good friend of mine, but I have trouble with Smith and Jones, so why shouldn't I have trouble with his name? Anyway, Kenneth was teaching everyone about this administrative procedure, and he was doing it quite well, and got probably the majority of the patriot community around the country interested in these private administrative procedures or administrative proceedings. Part of the private administrative procedures is what the Montana Freemen also used in their process, and they eventually had some other difficulties and problems which ended up putting them in jail, but it was not the process involving the administrative procedure which led to that. Now, the government systems today do not really run and operate on a judicial mode. Since the nation has no lawful government, since there is no law, basically the only thing that is the bottom line law is contract, covenant, or agreement of the parties. Private contract law. And in order to bring any proceedings into the public, you first must show that you've had a private agreement in the private to bring forth to the public. The biggest problem anyone can have is to presume that they're going into a court, civilly or criminally, without having finished an administrative procedure, and actually to think and believe that they're going to get a remedy in that so-called court by arguing their issues in that court. It's not going to happen. The only thing one can use a court for in this current scheme of politics and everything, government, is to literally bring to the court some kind of finished agreement or finished administrative proceeding. And the court has rules involving evidence, what they can and cannot see. And whatever you're going to bring to the court to have the court take mandatory judicial notice of the agreement of the parties is going to have to be in such a form that the court can see it under their rules of evidence. And if you go to the rules of evidence, it'll tell you flat out in one place under the hearsay rule that hearsay is not admissible as evidence in a court. And then you will see that they even define an affidavit to be hearsay. So what they're telling you is that an affidavit is inadmissible as evidence in the court because the affidavit is hearsay, and the hearsay rule says hearsay is inadmissible. Now, the technical reason why an affidavit is hearsay and inadmissible is because the opposite party does not have access and capacity to the affiant to cross-examine them as to their testimony. So ordinarily, you cannot introduce any kind of evidence into a court unless both parties or all parties have had equal opportunity to question or cross-examine or directly examine the party who is making the witness. But in the rules of evidence, they have 2 or 3 rules, the titles of which are something to the extent hearsay evidence admissible, and then the latter part of that title might be availability of the declarant notwithstanding they don't need the declarant, or there's a rule about admissible hearsay declarant available. In any event, if you go to the rules involving the exceptions to the hearsay rule, you will find out generally which evidence is admissible and which evidence isn't. In other words, they tell you hearsay is not admissible, and then they have 2 extensively long rules which tell you all the exceptions by which it is admissible. And under the exceptions, it tells you that it's admissible if the documents come out of a public office. That's why when documents are filed with the county recorder's office, they're made public. And if you file an affidavit in the county recorder's office and then you certify a copy of that affidavit out of the county recorder's document, it's admissible under the exceptions to the hearsay rule. But if you just take an affidavit that has not been lodged or filed with anybody in the public in an office, it's inadmissible. Therefore, the discussion tonight is on the role of the public notaries. And in fact, the public notary has played a very important part and role in what patriots do when they're working on these private administrative processes. And we have been talking in the past that when the other party fails to respond to your private administrative process, that you're going to go to a public notary in the commercial capacity of having that notary give you notice of the dishonor of the other party of having not responded to you and having been given notice that they had a duty to respond. And after they've been given their second opportunity to respond and they don't, we have talked in the past that the public notary was going to issue a certificate of protest or a notice of dishonor. And there are a number of people doing private administrative processes that have been having problems with public notaries and getting them to basically execute these documents because these public notaries say that's not our job and we're not going to do this. All we do is notarize people's signatures. Now, many patriots have used the certificates of protest and notice of dishonor as charging instruments against their opponents, in order to bring the opponents in as though being in that dishonor we're going to charge them with something and bring a commercial claim against them based on their failure to appear those dishonors or whatever. So they used the certificate of protest as though they were charging instruments civilly or criminally against their opponents. I propose you don't really want to charge your opponents and use them in that manner. It's unnecessary. First of all, if the notary public does not believe that he has a duty to do what it is that you're trying to get him to do, I would assume one of two things happens. Either the notary doesn't understand the true nature of his position, or possibly you're doing a very bad job of communicating what it is that you really are seeking in your process from the notary. And maybe you're charging the notary, which is bringing the notary or yourself into a dishonor to try to get the notary to do his job, in which case the notary does not have to do a job to respond to someone that's charging him, accusing him, or being in dishonor because of his process to the notary. In order to understand this process and put it in perspective, let's go back to what a public notary is, where that job came from in history, and what it was that created the position of the public notary and why they're there. If you go back and research notary, you'll go back either to Latin or French or back into the foundation of what that office was and how it came to be. And the office of the notary was really as a secretary to the court that was used by the court to take testimony from witnesses. When the courts were established by the kings, and every time you have a king's court, you have a democracy, a military government, which is exactly what we've got. The king's court usually sat where the king sat. And it would be very difficult for the king habitually to move around his kingdom and pull his court into every little city and every little burg in order to hold court for every little argument that was going on. So the king quickly decided that he would have to establish officials that would be able to do some of the preliminary work in these courts. And the position of a notary was one who was an officer of the court, sworn in and licensed by the court, to be able to take testimony for the king's court out of witnesses. And so the purpose of a notary is really to take testimony for the king's court. Now, we've already said that when it comes to the king's court, it's not a judicial system. All the king wants to do is act as a referee to resolve any differences between the parties that the parties have raised on their own issues. So the first thing that the king's court needs to do is get the pleadings and find out what the issues are, and if the issues are in dispute, we need to take the testimony, and many times that could be done by someone who can swear in the witnesses, take this testimony down, reach findings of facts, conclusions of law, put them into a document for the king or the king's lawyers, and then recommend to the king what the disposition of the case ought to be with regard to hearing the pleadings, the issues, and the facts taken before the notary, the officer of the court. The king would really only have to get involved if there were any disputes between the parties. Now, we've already said that the government today does not basically rule by law. It rules by executive actions in the administrative branch. And before anyone can go to a federal or state court with any kind of public actions involving the king's government, the king's administrative agencies must first hear the issue and arrive at a decision. And to go into the actual so-called courts, you can only have access to the courts on an appeal from an administrative order which came out of an administrative agency. And the agency basically creates its order after a so-called administrative process or hearing. If you're involved in any activity with government on any level, they won't take you to court until you first had some form of interaction with an administrative agent of that government. And basically your action with that administrative agent of that government, whether you understood it or not, was an administrative hearing. And certain facts were drawn up by the administrator of that agency or that hearing. They were put down in paper. They were reported to the agency with a conclusion of law, and they were filed with a public official. And it became official documents lodged in that agency's records. And the majority of times under the Administrative Procedures Act of the various government agencies, you have access to those documents by either requesting them or a procedure for getting them if the agency balks and just outright giving you a copy of them by a FOIA or some kind of a procedure. And if you get documents out of that agency, and if the keeper of that record will certify that it's a true, correct, and complete copy of the document coming out of that agency, that document now is admissible in any court proceedings without having to summons the agency record keeper. The document in and of itself, by its certified seal, is admissible, and the court will prima facie accept it without any other requirements or any other testimony. Since all the public agencies keep records of their administrative procedures and have filing methods with their clerks to keep these documents for a legal period of time and to produce those documents for other private official or public officials and certain private parties, those documents become the evidence in the administrative procedures as to why an agency made its decision, either correctly or incorrectly. And those documents can be summoned into proceedings if necessary. I put it to you that the government is being run privately under private international law, since there is no valid constitution. So what the government is doing with their Private Administrative Procedures Act is just telling you we're running our government privately under private administrative procedures, under private international law. We keep our records. We ask you to become involved and resolve the issues. You have an opportunity in the administrative proceedings to become involved and help us create the record of our transactions. And you have access to those records at any time before, during, or after the proceedings that the records are there. And you can certify them out and use them in any so-called court for purposes of appeal if you do not like the administrative judgment. Are not the public agencies doing exactly the same thing that the Patriots are doing with their private administrative process? If the Patriots are keeping all the appropriate records and doing it correctly? Absolutely. What's good for the goose is good for the gander. Now, the only problem comes is when we go back to Genesis 23 and we see how Abram negotiated an agreement to purchase land to bury his relatives that passed away from foreigners. It was not only sufficient to get the private agreement between the parties themselves, namely Abram and whoever he was going to buy land from, but it was further necessary, since he was in a foreign country, to make sure that the private agreement he negotiated with the party he bought the land from was also lodged in the public of that foreign nation, so that everybody in the public sector, as a second witness, had noticed that the foreigner Abram had purchased this land and under what terms and conditions it was purchased. Abram negotiated a private administrative agreement with the private parties. But by time he was finished with the agreement, and by time he carried out the exchange of the consideration, so that the agreement was executed, he stood in the public square with the other party to that agreement. And in full hearing and seeing distance of the foreign public, they announced publicly what the decision was, i.e., it was registered to the public as a second witness. Now, when the private administrative agreements are finished, the question is, why is a notary involved? The real reason the notary is involved is because the notary is the agent or the window between the public and the private sectors in these negotiations. And the notary has been licensed by the king to take testimony from the private sector so that that testimony can be brought over into the public sector and filed and lodged in the appropriate offices in the public sector, so that the public has the second witness to the agreement that took place in private. And that public notary in the private agreements and her witness, signature, and seal is significant because she is the equivalent of the public administrative hearing officer. She is the one that is listening to the private testimony, and she is going to certify that testimony by her seal as being the second witness to be brought over into the public. So when you go to the notary, and it's time that you're asking the notary in a commercial sense to issue a certificate of protest and a notice of dishonor because the other party has failed to appear, That might be way too coarse or too much reality, probably, for what we're really doing here for their court. Why don't you approach the notary public and do the approach based on the history that we just talked about? And let the notary public understand that is a licensed or sworn-in officer of the public tribunal. That it is her job, basically, to certify the testimony of parties involved in any kind of administrative proceedings. To bring the record of that testimony, and not only the testimony, but the record of the evidence that's in that administrative proceedings under her seal for the purpose of bringing it into the tribunals for public notice and awareness. And that when you go to the notary public, what you are basically doing is don't treat the notary as someone that I'm just here to get your seal and your stamp, just put it here, bang, bang, thank you, ma'am, I'm out of here. That notary public is your administrative officer in your administrative proceedings if you're doing it correctly. Therefore, you just don't bring the final document to the public notary and say, hey, I'm here to tell you that this other party is wicked, terrible, and awful and didn't show up, and I want you to sign this which says he didn't. Thank you very much, I'm out of here. What you're basically doing is you're going to explain to the notary what you're doing here. Hello? Joe and I had a problem. And in this problem, I wrote the first letter to Joe. Here's my pleadings, a copy of which is right here, sent out a couple of weeks ago. And attached to that is a copy of the certificate of service or the certified mailings or the green cards or the proof of service. And I know he got it. And you can see in the process I requested that Joe respond to me and try to resolve this matter. And I'm here today to give you witness that the time is up, and I'm requesting that you notice that Joe had an opportunity to respond, and I really want Joe to respond because I sincerely want to try to resolve this issue here. It's in Joe's interest and mine. And I have no ill will against Joe. I want him to show me when I'm wrong or to help me agree with me when I'm right. And I'm involving you, Miss Notary, because your job is to take testimony for courts. But we can't go to court until we exhaust our private administrative remedies. Therefore, I'm begging Joe to answer me and help resolve this. But the rules of procedure are very clear commercially, civil process, criminal process, you name it, that if the other party will not voluntarily come in and address these issues, then the civil courts say that he's in default, the criminal courts say he's in dishonor, the commercial courts say that we ought to issue a certificate of protest and a notice of dishonor. What I'm suggesting to you, notary public, because as an officer of the court, you have the capacity to view the testimony of the parties and certify that this is their evidence and there is their testimony under oath, and to put your seal to that so it will save the courts an appreciable amount of money and time. And I'm requesting that this process move forward, and you're basically the administrative agent appointed to look at this evidence pursuant to your license as a public notary to take this evidence and observe this proceeding. And what we need to do in this administrative proceedings is to give Joe, the other party, an opportunity one last time to come back and put his input into this matter. And you can see that I have typed up a letter to that effect which I'm requesting that you, the administrative agency, should endorse at the bottom here as the agency administrator and request that other party to do this if they are going to do it. And it suggests to the other party that if they deliberately do not respond, then the other party is agreeing by their failure to respond where they have a clear duty to do so, that they're tacitly approving the following facts with regard to this matter and the settlement thereof. And we're noticing that party, that if they fail to come back, it will not be a default judgment. It will be an estoppel on them because of their actions, because they were given notice twice, an opportunity to respond when they had a duty to resolve it. And by their dishonor and their failure to come in and respond to it, that they are agreeing to be placed in a condition of legal estoppel where they are waiving any response whatsoever in this matter. And they will further allow these facts now to become the agreement of the parties in this matter to move forward into any kind of execution with regard thereto. Now, if the notary public will agree that that's reasonable and we can move forward, then we're putting the other party under a 3-day notice to respond to correct this matter. If the other party fails to respond in that time, you go back to the public notary, and what you are doing is asking the notary to certify the documentation that you've brought to the notary as your administrative proceedings so that it can be recognized through her public seal as evidence that is admissible in any kind of action in the public. Your purpose in doing this is not to charge the party who has failed to respond. Your purpose in doing this is to be able to put a documentation in the public from the private so that all of the parties and the public at large will be able to understand that there is an agreement of the parties created by notice and opportunity, and that you are not just stating that yourself, but there is a public official licensed to the court that has taken notice of this evidence by agreement of the parties. That's what you're asking the notary to do. That is within the scope, purview, and capacity of a notary to perform. There is nothing here that you're doing that is any different than what the administrative agencies are doing. The administrative agencies head agent taking whatever the testimony is, I will assume and presume has an oath of office with the government. And I will assume and presume that he has been given authority or a draft by some party to carry out his duty as the administrative officer in that hearing. Therefore, third parties have given him that capacity. When the testimony is taken, if it is taken under oath, it is preserved in a record. It is transferred to a clerk who has the job and the fiduciary capacity to preserve that record, make a copy of it, and certify it. And if there's any further problems between the agency and the parties involved in the administrative process, that record can be brought forth, and that record denotes the only evidence that the tribunal can see and deal with in the proceedings. Because the first court case is the first appeal of the administrative record. And a rule of court actions on appeals is very simple. You cannot introduce any new matter on appeal. Therefore, if you're going into the IRS court trial, the traffic court trial, or any other trial, there is a very good likelihood that any argument and any evidence you're trying to introduce into that proceeding will not be received, or if it is received, it will be ignored under the rules of procedure because you're on an appeal of an administrative proceedings. And being on appeal of an administrative proceedings, you cannot introduce any new evidence that was not already introduced at the administrative level, which is the police officer on the scene, or which is the zoning commissioner, which issues you the citation for non-appropriate parking lot, or the IRS, which says you didn't pay your taxes. If you're not in their record, you can't raise the issue in trial. You better go back to the administrative proceedings and reopen the administrative proceedings by private letter rogatory and drafts and new evidence or new issues and pleadings at the administrative level, have them append their administrative records, and have a redetermination based on the appended record, or else you will not prevail in the so-called trials. Now the same thing's true in private. If you're trying to deal privately in a matter, your administrative officer, hearing officer, is the public notary. And you are bringing all of your private material and evidence and record to that public notary as your hearing officer for your private administrative proceedings. And until that public notary issues a seal on your record, you haven't got a record which is going to be seen and recognized in the public tribunals for execution or for proceedings if and when the other party comes in and wants to start doing what most of the stupid patriots have always done in the past, wait until the court starts up and then go in and argue a brand new argument. Court is not a place for a new issue of fact or a new issue of law. Remember, the New Testament says if your issue is not settled with your opponent before you are in front of the judge will throw the book at you because he cannot see your issue, facts and argument. And since he can't see anything you've done because you brought him no record sealed by a public officer who can take testimony, and he is on appeal, you have no remedy. So it's absolutely mandatory to bring your private record over into the public sector by way of the public notary's seal. And the history shows us that the King's Court placed those officers there to go out in the Netherlands, where all these private controversies are going on, and if necessary, take the record so that when and if it comes to the King's Court, the King will have something to rule on. And that's what this process is doing. Is there any question? Any comments?
Got a question for you. This is Pete. You showed that the correct procedure is to have the notary essentially, we'll say, prepare the paperwork. Obviously, you do the paperwork for his signature, but it's as though he prepared it.